Passing along resources to children or grandchildren who are minors can be a tremendous gift, but there are pitfalls in many situations because minors and those with special needs have some significant legal limitations and unique planning considerations. Today, we want to discuss what happens when your beneficiaries are minors or have special needs. Spencer, today we want to talk about two categories of minors, or two categories of beneficiaries, I should say. One, minors, and another, those with special needs. And we're going to cover each of them in their own right. So let's start off with what happens if your beneficiaries are minors. So you and I both have minor children. What would happen if you and I were to both pass away, or both of our spouses were to pass away? How would resources get allocated to them?
So the big picture is minors can't inherit assets directly. They can be named as beneficiaries, but not direct. So what would happen if you named a 12-year-old as a beneficiary is the court would need to step in place and have a guardian or custodian named there. Now that can be expensive to get to that point. Better, you go ahead and you select that person and you put together a trust. Oftentimes we'll see clients put in place a testamentary trust where they set up a vehicle basically for assets to move through, to name a trustee that they are comfortable with, and then they still have the beneficiary as their intended recipient. If you don't do that, then there can be higher levels of cost and more winding and difficult legal elements.
Right. Okay. So I think that's one thing that we really need to focus on here is the reality that whether it's a minor or a special needs beneficiary, you need to appoint a trustee, someone that you can really, in a lot of ways, trust to make wise decisions on behalf of your minor. What are things to consider when we look for a trustee?
Well, you want to have someone that is going to be comfortable sitting in that role for many years to come. You don't want to name someone who maybe they're aging and if you name your father as the trustee for, your son or your daughter, but your father is 85 and in decent health, but is still 85, that may be fraught. You want to name someone that ideally is going to be there for the next 10, 15 years at a very, very high level of engagement, mental capacity, those kinds of different things. So that's one consideration. A second consideration is you want to have someone who will also be able to understand the trust and have the diligence to move through the trust verbiage and implement those procedural elements with excellence. Now, they don't need to necessarily be a financial professional. They just need to be someone who is committed to you, committed to that beneficiary, and diligent. Right. So oftentimes that will be someone that is close to you, both relationally and geographically, but it doesn't have to be someone that is close to you geographically. It does have to be someone that's going to be engaged enough and can do the things that need to be done to make sure that distributions happen and wise decisions are made.
Right. And I think with that, they need to be someone that may also be willing to dig into some of the morass that comes with an IRA. Because as we've seen with the Secure Act, the beneficiary rule changed a little bit. And so you can stretch up to 18, but then you've got 10 years to distribute thereafter. And so your trustee really has to be willing to handle a little bit of that nuance if they're going to receive assets like assets from an IRA.
Right, and you want someone that's willing to talk through some tax planning, understand general trade-offs that you might face there, because it might be better, to your point, to do kind of equal distributions over 10 years, or you might be at a point where you realize that the beneficiary at age 18 is not at all ready for those assets and may need to have smaller distributions up until, say, age 25 and then larger chunks thereafter.
Right. Okay, let's talk about that tax implications thereof. Because obviously when assets go into a trust, they're taxed differently than if they're taxed to an individual. Talk us through some of that.
Well, any good estate planning attorney is going to put verbiage into the trust that's going to think about this. So for instance, with resources that a trust would receive that would be IRA resources, pre-tax resources, they're going to have some kind of see-through language, where the distributions can be passed on through and distribution ultimately is going to come out of the trust, but it's going to be pushed to the beneficiary ideally, so that you're not paying trust tax rates. You're paying tax rates ideally, again, at a much lesser level for the beneficiary. As well, when we think about tax implications, we need to have a trustee that's going to understand some of the trade-offs that would be for non-qualified resources or other types of investments that might be there to make, again, some decisions that are going to be in the best long-term interest of the beneficiary.
Right. Okay, that's great. As we think about making this transition from minors to special needs beneficiaries, before we do that, anything else we want to touch on before we make that transition to special needs beneficiaries?
I think the only other thing that we would say is it's good to think through what age you're going to be comfortable with your heir receiving big chunks of those resources. So to your point, you may have resources that start coming out at the age of majority at 18 or 21, whatever state you live in, particular there. In the state of Tennessee, age of majority is 18. But there are ways that we have even gifts made during a lifetime to a UTMA account, Uniform Transfer to Minor account there, where the recipient would then be able to access the resources at age 21. Mm-hmm. Now, in an UTMA type of situation where you make that gift, and let's say you make it when child's 2 years old, and then resources grow for 19 years. Say you put in, $50,000, and 19 years later is $150,000. Well, that's a significant sum. Mm-hmm. For some guys, for some kids, when they're 21, they may have a great head on their shoulders. They may say, hey, this is going to be a down payment on a home in a few years. I'm going to keep these resources right here. There are a lot of 21-year-olds, though, that's not what is on their mind. And the challenge with an UTMA or an UGMA account is that when you reach that age, when the resources become theirs, 21 or 18, depending on the account, depending on the state, you have no more control.
Right.
So you have to be really careful on those types of accounts. Whereas a trust, as we've been talking about, you can decide what age they will receive lump sums.
Right.
And that might be, you might say, okay, I want a third of the resources to go at 25 and a third to go at 30 and the remainder of the resources to go at 35. Or you may have some other sequence. Like we've said, the clock starts ticking, and you typically have 10 years to the age of majority to fully distribute a IRA. So you got to be very careful on that. You don't want to say, okay, well, the only asset that's coming in here is an IRA, and I'm not going to allow a full distribution of these assets until the kid gets to be 50. Okay, well, now you're asking for a lot of tax probably on those resources when they have to be fully dispersed from the IRA, but still held in the trust. Right. Ideally, we want a situation where IRA resources, as they're pushed out, they go out to the beneficiary and they're taxed at beneficiary levels.
Right.
So again, paying particular attention to what are the assets in the trust, what's the distribution cadence, and when do those lump sums need to come out. It could be different for different heirs as well. Yeah. So bear in mind that sometimes you can treat heirs equally, but not in the same exact manner.
Mm-hmm. Yeah. That's great. Okay, so let's shift now over to special needs beneficiaries. And I think the primary concern here is both allowing them to have enough resources to live out however long their life expectancy is, but also to not disrupt potential eligibility for Social Security income or Medicaid. So what are some things that we need to know about gifting to a special needs person through beneficiary designations or in your will?
Well, the first thing to note is exactly what you talked about. There are some elements that we need to be aware of in terms of governmental aid, where getting too much as a beneficiary can disqualify and can actually harm that person. Let's say you received an inheritance and you are a person with special needs. You are on governmental assistance for some medical benefits, for some other support elements. Let's say you receive $50,000. Well, that $50,000 could disqualify you from some of those benefits that are far more lucrative, are far more helpful on a financial basis than that $50,000 will be. So you don't want to disqualify and then have to requalify for benefits there. That is very, very difficult. So we've got to be wise and cognizant of that particular issue. If a trust is set up correctly, where resources go in and you have a trustee that can then make decisions about what is distributed out and for what purposes, then oftentimes you can make distributions that will help the beneficiary, but will not disqualify them from aid.
Okay, so let's talk about those special needs trusts. What are kind of some of the basic things that we need to know? There's this idea of third party versus first party. What are some of the differentiating factors between those two? And especially as resources go in, what are some of the primary concerns?
Well, you have third party versus first party. Now, first party, it's a self-settled trust. So this would be you have these assets and then you put them into a trust. Generally speaking, that can disqualify you from benefits because they're essentially your assets and they're being placed into a trust. Now, the trust may have beautiful language and such, but oftentimes it's going to be difficult to convince the government that those aren't actually your assets. If you have a trust that's set up that's independent of you, you've never owned those assets, and let's say they come from a grandparent or an aunt or uncle, or even a parent there, and that person puts those resources into the trust on your behalf. In essence, you are the beneficiary of that trust, but you've never owned those assets. Then it's a different situation. Generally speaking, if the trust is set up correctly and the verbiage is good and the trustee abides by everything that the trust document says, oftentimes then you will not be disqualified for government assistance because they've already thought through all of the different categories and said, well, you can take a distribution for this, but not this, because some categories are disqualifying and others are not.
Right. And that kind of dovetails into something we've already talked about once, but the idea of you really need to pick a trustee that you trust that is going to think on the best interest of that beneficiary. What are some crucial considerations that are maybe more true for special needs beneficiary trusts than they are for maybe minor trusts?
Well, there is more complexity to these types of trusts. So in some ways, it would be more helpful to have an attorney, as a trustee in this particular area. The challenge is there's a lot more work for these trusts. So if you're naming an attorney that you're paying to administer this, the expense can add up fairly quickly. So you've got to be careful on both sides. You want somebody that's going to be diligent, that's going to be devoted to the beneficiary. Oftentimes there is a loved one, might be a family member, might be a close friend, who just feels called, so to speak, to put the time, invest the time here. You may even pay them on some level, but you might not pay them at quite the same level that you'd have to pay an attorney. Maybe there's a willingness to do a significant amount of work and just charge a flat fee or something like that, for the administration. So you would like to have someone, again, that has a level of diligence, is always going to be acting in the best interest of the beneficiary, but also isn't charging you an arm and a leg there for that.
Okay, so finally here, we want to think about coordination with an entire estate plan, specifically for special needs beneficiaries. What are some of the things that we need to consider for the entirety of the estate plan?
Well, there's a lot of different things. One question would be, how much do you want to put into this special needs trust? If you put in more than you need there, then obviously those resources are tied up. Sometimes the trust itself can have tax consequences assigned to it that would be detrimental compared to where they could be otherwise. So you want to think, how much is enough to put here to satisfy this particular goal? That's probably the first and hardest thing. The next piece thereafter would be, how do I make a plan here that addresses tax planning? Because the tax components of this can be very, very different. From an ease of administration side of things, let's just say that you have a non-qualified account that has $2 million and you have an IRA that has $2 million. Well, and let's say you have two beneficiaries. You have one that has special needs. You have one that will be receiving resources outright just at your passing. Well, from an ease of administration side of things, it might be easier to have the $2 million that is non-qualified go to the trust, because there's not going to be any kind of required minimum distribution. There's not going to be any of that IRA difficulty, that you would have there. And if assets are held in trust there from that IRA, the trust tax brackets can grow quickly there. So that would be the nice side of things, but it might not be the most advantageous from a tax planning side of things. Because if you have two beneficiaries, again, and let's just say you have one beneficiary that has a really high level of income and receives that IRA, every distribution, let's just say you have a daughter who's a surgeon and is making $500,000 a year. Your daughter is going to be paying a lot for every bit of distribution that you have there. Say you have a son that has special needs. It might be more advantageous to leave the son with the IRA, be able to take out those distributions over time, and to do so in a way that would be more tax advantageous. But again, you have to think through what happens there, and has that son qualified maybe for lifetime distributions? There are, generally speaking, with the Secure Act, you've got to take them out within 10 years if you're a non-spousal beneficiary. But there are categories of beneficiaries, including those with special needs in certain provisions there, that you can have a lifetime income there. So lots of different considerations, but you'd like to have someone who will help you think through this as you put together an estate plan, looking at who needs to be named as the trustee, what are the tax trade-offs, how much is enough, all these different things together there.
Well, it's good. Before we close out today, anything we need to touch on that we haven't considered, either with minors or special needs beneficiaries?
The only other thing that I would say is make sure that within your overall long-term planning, you're thinking about the gifts that you might be able to make on an annual basis. Living and giving earlier rather than later oftentimes has very, very good outcomes, because you can see how a beneficiary will use those resources. Even if you're giving an extra amount to a 15-year-old, you can see how are they processing, this gift. So that can be quite helpful. The other thing that I would say is looking at using 529 accounts. So if you have, on the minor side of things, if you have a 529 account that is educationally focused there, that can have some helpful tax consequences if those resources are ultimately being pushed to a 529 account. Let's say non-qualified resources ultimately get pushed into a trust and then out to a 529 account to fund. That can have a better tax consequence. By the same token, if you're using a 529A or 529 ABLE account for someone with special needs, that can also have some nice tax consequences there. So there's too much to get into there for this podcast, but know that there are some other vehicles that you can use that have some tax preferences, both for minors and those with special needs.
Great. Well, thanks for walking us through that, Spencer. If you have beneficiaries that are in that minor age range, whether they're kids or grandkids or those that have special needs, we would say it's really critical that you talk with an estate planning attorney. Clients, we would love to walk with you through what are those considerations, but this is something that at the end of the day really needs to be done hand in hand with an estate planning attorney, not with us as your financial advisors at the end of the day to really draft the documents. We can't draft these documents, but we'd love to have conversations with you. If you have questions, feel free to leave them in the comments below. And until next time, take care. If you like these financial planning videos, please share with a friend. And if you have questions, go to our website at SeriousRetirement.com. This content was provided by Retirement Planning Services. We are located in Knoxville, Tennessee. You can visit our website at SeriousRetirement.com. The information in this recording is intended for general educational and informational purposes only and should not be construed as investment advisory, financial planning, legal, tax, or other professional advice based on your specific situation. Please consult with your professional advisor before taking any action based on its contents. Advisory services offered through Retirement Planning Services, LLC.